AOC-4 non-filing is a penalty explained, section 137 and 454. Why? In this, we are going to deeply analyze an adjudication order. This is passed by ROC Chennai under section 454 of Companies Act, and we can see the very recent order, 2nd February 2026. This power is given under section 454. ROC generally empowered, because of this 454, legally empowered to issue SOCAS notice, conduct hearings, impose monetary penalties, and pass binding orders. If you see the company name here, Ramesh Nidhi Limited, this is the company. This company registered in Tamil Nadu, Kanchipuram district. Officer and default, here individual. Officer and default. Officer and default, the Nidhi company generally do not have CFO or MD, so the director becomes officer and default. Here the applicable provision section 137. If you see section 137, subsection 1 and 2, if you see section 1, subsection 1 and 2, every company must file financial statement along with the notes, auditor's report within 30 days of AGM using form AOC-4. 137.3 talks about the penalty clause. If the company fails to file AOC-4 within time, penalty on the company 10,000 initial penalty, 100 rupees per day continuing default. The maximum cap is 2 lakh. And penalty on director, officer and default, 10,000 is the initial penalty and 100 rupees per day continuing default. So maximum cap is there 50,000 per person. Here if you see the facts of the case, company filed NDH4. The company filed NDH4. The purpose is for status updation, Nidhi company status declaration. But ROC rejected. ND4 rejected on 31st July 2024. Reason mentioned is AOC-4 for the financial year 22-23 not filed. So actual default identified financial year 22-23. AGM date presumed September 2023 and due date for AOC-4 31st October 2023. Actually they filed on 27 November 2024. So the delay is 393 days delay. This is what, based on this penalty triggered. Company's defense, company argued that company submitted a reply AOC-4 was filed before issuance of adjudication notice. Fees and additional fees were already paid. So claimed protection under section 454. Subsection 3, because section 454 subsection 3, when penalty can be waived. Penalty may not be imposed if default is rectified before or within 30 days of adjudication notice. But ROC rejected this argument. ROC said default was not rectified within the statutory time. Rectification happened only after NDH4, this rejection. After rejection of this form. Then hence 454.3 relief not available. And then late compliance, even though they filed, late compliance cannot claim as a immunity. So notice issued on 27th November 2025 and then 30th December 2025 e-hearing scheduled but no appearance. ROC proceeded with ex parte order. Then penalty, rule 3, sub rule 8, ex parte order. Final finding with ROC is yes, section 137 subsection 2 violated, delay 393 days, rectification was belated, so penalty is mandatory. It is not a discretionary. So on the company, if you see penalty here, 49,300. On the company, maximum it can reach even 2 lakh, but penalty levied is 49,300. Additional penalty per day. Here it is not mentioned. So the penalty on the company 49,000 and on the director 49,300. Here maximum it can reach 50, but the company levied 49,300. So ROC imposed penalty almost the maximum threshold for director. So and also directed payment shall be done within 90 days. within 90 days of receipt of order through MCA adjudication portal, director must pay from their personal funds. This is mandatory. And payment e-adjudication portal, there is a right to appeal. If they want, they can approach to RD within a period of 60 days. This is a right to appeal with a certified copy. Consequences of non-payment: if not paid, then again consequences are there. Section 454(8), adjudication of fines, possible prosecution and disqualification risk of the director. So this is a very, very important key compliance takeaway. AOC-4 filing is very important. Hope we are clear. This is a very recent order. This is available on MCA portal, 2nd, 2026. Thank you.